is a property manager for a Queensland real estate agency. Lee's company is firm but fair to protect the interests of all parties to a tenancy. Property owners readily use Lee's company because they have an established reputation for complying with legislation and working with tenants to resolve issues wherever possible. After seeing a recent court outcome in the media, Lee phoned the RTA to discuss the tenancy agreement that the agency had been using. Their version includes additional terms to the tenancy agreement, which is sometimes called special terms. Lee was advised by the RTA that some of the special terms could be unlawful because they required the tenant to purchase professional goods or services. If a special term states that a tenant must provide a receipt or engage a professional, it is a breach of Section 171 of the Act, as they cannot be required to buy or agree to buy goods or services from the lessor, lessor's agent, or a person nominated by the lessor or agent. This means that these special terms placed an additional burden on the tenant which was already provided for in the Act, or sought to evade the obligations of the landlord or agent under the Act. Lee was shocked and concerned that the agency might be breaking the law and asked the RTA what would happen. The RTA advised that if a penalty infringement notice was issued, there could be a penalty of $1,200 or more for the agency, while an individual could receive a penalty of more than $250. If the matter was prosecuted in the Magistrates Court, the penalty for the agency could be more than $12,000 and up to $2,500 for an individual. There were over 200 tenancy agreements in place with these special terms included, and Lee did not want to receive a penalty infringement notice or defend a prosecution in the Magistrates Court. Lee asked the RTA what should be done. The RTA advised Lee that if the property owner or the managing agency took reasonable steps to remedy the situation, the likelihood of the RTA taking enforcement action would be reduced. Lee could issue a written statement removing the unlawful terms in the existing tenancy agreements, or notify tenants in writing that the special terms would no longer apply, effective immediately. Immediately after getting advice from the RTA, Lee's agency amended the tenancy agreement by removing any unlawful terms. The agency also added information to their vacate packs reminding tenants of Section 188 of the Act, which states, tenants must leave the premises and inclusions as far as possible in the same condition they were in at the start of the tenancy, fair wear and tear accepted. At the start of each tenancy, Lee and the tenants complete an entry condition report and attach photos to record the standard and condition of the rental property. Then, at the end of the tenancy, an exit condition report is completed with more photos when the tenants vacate. This helps to protect both the tenant and Lee to avoid disagreements and disputes about the condition of the property when the tenants leave. Importantly, Lee learned that the way in which that same condition, less fair wear and tear, is achieved at the end of the tenancy is entirely up to the tenant. That means that while Lee's agency can provide a list of companies to assist tenants to return carpets and other items to the same standard, tenants will not be obliged to use these companies. 1 year later, a tenant made a complaint to the RTA about unlawful terms provided in the tenancy agreement by Lee's agency. The RTA investigated the matter and sent a letter to Lee asking for a response to the allegations. The RTA was provided with evidence that proved the agency had written to tenants to advise that the terms were unlawful and would not be enforced, reminded tenants of their obligations under the Act when they provided notice to vacate the property, advised the tenant in question that the terms would not be enforced, and had not made a bond claim on these grounds. The RTA decided that the case would not be progressed. the tenant was advised that no penalty or prosecution would be pursued. For more information on special terms, RTA investigations, entry and exit condition reports, please contact the RTA on 1300 366 311 or visit rta.qld.gov.au.